May it please the court, Robert Garson for the Cloister East Inc., the Drabenko Brothers Realty Inc., Judicial Drabenko, Nicholas Drabenko, the estate of John Drabenko and Walter Drabenko. From what the court said previously, they've obviously read the briefs that have been put before the court in assessing how much time I should be given, and I'm grateful for that. But, Your Honours, this case involves issues of access to justice, not just for Cloister Cafe and the individuals who held the liquor license, but also, as His Honour Judge Kaplan before the SDNY recognized, for hundreds of businesses that may, for want of all knowledge, may have forgotten to dot an I or cross a T, but like Cloister Cafe, have paid taxes for the past 33 years, quarterly taxes for the past 33 years, were all up to date in respect to franchise taxes.
I'm curious, counsel, so you're saying that the corporate dissolution of Cloister East is a small matter that Cloister overlooked?
Well, Cloister didn't know it, to be fair. Cloister didn't know about it up until this was brought up before His Honour Judge Kaplan in argument on August 19th of 2020, and Judge Kaplan said, yeah, that's not important. For the purposes of the determination of the order of summary suspension which had been brought in. Thereafter, when we were having the argument about whether or not Article 78 could be allowed for an order of summary suspension, His Honour Judge Kaplan, and that's the issue that gives rise to the secondary, they're not secondary in status, but the secondary points of appeal which relate to judicial estoppel. As to what transpired was, at first the Attorney General said, Article 78 is not available to Cloister Cafe down in the state court because it's not a final proceeding. His Honour Judge Kaplan said, well, if you're saying Article 78 isn't going to be available, I'm going to retain jurisdiction here, unless you tell me differently, unless you tell me that you're not going to oppose it down before the state court. On the issue of order of summary suspension. That resulted in what we see at A709, A710 within the record of the Attorney General putting in a letter to Judge Kaplan saying, we will not oppose the Article 78 in the court below on the order of summary suspension.
But counsel, what difference does that make? If the corporation is dissolved, it lacks the legal capacity to sue. Are you saying that that's a matter that can be waived? With respect,
well, first it can be waived. Capacity can be waived. There is abundant case law in relation to that.
And the AG's office said that they would.
The AG's office
in the letter said they wouldn't. But does that bind the court? Does that prevent the Article 78 court from addressing the lack of capacity?
So two issues in relation to that. First, it's a defense of lack of capacity, which is asserted. Surely a court can bring it up sua sponte, but if a state agency waives it, then says, yes, you're allowed to sue or you're allowed to bring an Article 78, but then in a separate proceeding come back and say, oh, no, that was just in relation to the order of summary suspension, but when we're looking at the revocation, that doesn't apply. With respect, that is something that as lawyers, as judges, that strikes at one's guts, that when you have a lack of equanimity in the law, when you have the AG saying one thing in relation to one aspect and another thing in relation to another aspect, that's not the way a state agency, when I was prosecuting, that's not the way that I behaved, because there should be equanimity running across the law. Turning to Your Honour's point in relation to capacity, there's a two-stage test in the law, and the case law has been a bit scant, and we point this out within our briefs, because the case laws, we have it in 151st Street Liquors, it relies upon B&O, but B&O states two things. He says, first, because the corporation was dissolved and it did not seek reinstatement, therefore, it lacked capacity. That's because B&O then relied in turn upon Louisa Corporation or Louisa Capital Corporation versus Gallo, which goes into a very detailed analysis of the fact that the seeking of reinstatement can preserve capacity. And what we had here with Cloister Cafe is the Cloister Cafe from 2015 involved in a tax audit, a sales tax audit, not a franchise tax audit, because let's get this right for the court. This is a tax law. Tax 203A lays out the social contract between corporation and paying taxes. You pay in, therefore you can use the beautiful instrumentalities of the state in relation to franchise tax. This, we presented evidence. You had evidence from Mr. Eletto at 1061 to 1067, who is an accountant, stating this corporation has paid its taxes and is in an active negotiation when it comes to sales taxes, and which, as it transpired, 2 months after the proceeding denying them capacity, they were fully reinstated.
So counsel, I'm just gonna like ABC this. So there's other situations where parties are deemed to lack capacity, right? So for example, a minor, court wouldn't really care if the parties agreed that the minor could consent to a contract. Court would never follow that. Or you have a decedent, and an estate has to be created, right? And an administrator has to be appointed, and the court would never be bound by an agreement, for example, amongst the heirs. We don't care about that. So you're saying in this situation, the court, to again reflect on what I asked at the beginning and what Judge Acosta just followed up with. So you're saying that the issue of the corporation's dissolution is something that the court can simply ignore?
No, I'm not saying that it should be ignored. There's the dissolution. There's a 2 to 3 stage test: dissolution, delinquency, and a lack of seeking reinstatement. Now,
But the taxes weren't paid until after the judgment.
no, Your Honor. 33 years of taxes were paid, franchise taxes were paid, quarterly taxes were paid. Those were delivered to the court. The court had those.
So
There
what taxes were, the
was an issue of-
$140,000?
No, well,
The tax warrant that was issued in 2019.
there was a sales tax audit, which is different from what tax law 203A deals with, which is franchise taxes. It was a sales tax audit that started in 2016. They were under active negotiations for. They settled for $55,000, and then it was later, 2 months after. The capacity was torn away from this corporation. The corporation was rehabilitated. It is a fully.
But is the rehabilitation retroactive? Because
Yes.
what's your authority for saying that?
Tax law
Other
203A
than,
subsection 7.
I beg your pardon?
Tax law 203A subsection 7. Once the taxes are paid, once a corporation has been rehabilitated, nunc pro tunc, everything goes right back to the beginning. Every corporate act that a corporation has done, nunc pro tunc, is rehabilitated. It is fully retroactive.
And that means that in Article 78 that was brought when the corporation lacked capacity, all of a sudden springs a new life?
No, it doesn't. And that's the problem therein. And that's why the Larissa court gave that 2-stage test, because Your Honor, with respect, is focusing on dissolution. Your Honor is not focusing on the 2nd-stage test, which is clearly there on the face of the case law that says you have to, that there's a burden to show not just dissolution, but there's delinquency and a corporation that is not seeking reinstatement. This corporation was seeking reinstatement. The problem is that with an Article 78, as Your Honor knows, there's such a short statute of limitations. There's a 4-month statute of limitations. So here, someone like Cloister East that has 40 employees, that has been a company that has been existing for, that has been operating for a long time, now has no opportunity to go back and redress the terrible overreach of the government previously. I know I've gone way over time, and I apologize.
Thank you, counsel. So if you could please first address, after you identify yourself, address the issue of the letter to Judge Kaplan and, I mean, counsel didn't call it that, but the sophistry involved in then preventing them from suing in the Article 78.
Of course, Your Honor. My name is Blair Greenwald. I'm appearing here on behalf of the respondents. I'd like to make a few clarifications of what was going on and what the letter actually said. So the particular statement in the letter is that if plaintiffs commence an Article 78 proceeding in state court seeking judicial review of the order of summary suspension, the SLA agrees that it will not raise as a defense that such court lacks jurisdiction to review the suspension order on the grounds that it is non-final or otherwise. Here, Judge Kaplan was concerned that if the Cloister East challenged the suspension order in state court, it would not be able to get review of its claim that the suspension order violated procedural due process because there was not a sufficient post-deprivation hearing. When petitioners then filed a Article 78 proceeding in state court, not this one, but one before, challenging the summary suspension order on that basis, the SLA adhered to its promise and did not challenge that order as non-final. In fact, Judge Engeron ended up dismissing that case as moot because petitioners got what they wanted and the summary suspension order was vacated. Judge Engeron actually invited the petitioners here to file a plenary action to pursue their constitutional due process claim if they wanted. Petitioners neither appealed that order nor filed a plenary action. In this separate proceeding challenging the SLA's cancellation order, the agency then presented the argument that petitioners here lacked legal capacity. It therefore was not directly contrary to what the SLA said in federal court, nor was it somehow contradicting what Judge Kaplan was trying to ensure with respect to an action in state court challenging the suspension order. But also, I just wanted to add that Your Honor's questions are correct. Even if there is some kind of waiver that did occur here, the court can sua sponte, as petitioners acknowledged, look at lack of legal capacity and dismiss on that basis. If there are no further questions on that point, I would just like to address the actual lack of legal capacity here. So Supreme Court properly concluded that petitioners lacked capacity to sue because they didn't pay their back taxes and reinstate their corporate status in order to properly commence this proceeding. Cloister declined to take these steps despite ample notice and opportunity to do so, including when it was served with a tax warrant in 2019 or when the SLA noted its dissolution in late August 2020, many months before this proceeding was commenced in February 2021. This case is therefore squarely controlled by 151st Street Liquors, which held that a dissolved corporation lacks capacity to sue. Neither of Cloister's arguments made here overcome this controlling precedent. Cloister argues that Supreme Court was somehow required to conduct a full-scale evidentiary hearing on whether Cloister had, in fact, had a tax deficiency. But there's no dispute that Cloister remained dissolved when this suit was brought, and that's all that's needed under the tax law and the BCL to find lack of capacity. Moreover, it would not have been appropriate for Supreme Court to entertain a tax challenge in this summary Article 78 proceeding against the state liquor authority, which had nothing to do with the assessment of a tax deficiency in 1993 and nothing to do with the proclamation of dissolution that was issued in 1993. If Cloister had wanted to challenge those issues, this was not the proper proceeding against the SLA to do that. And finally, I'd just like to mention that counsel has made arguments that simply showing some efforts to pay taxes and seek reinstatement should somehow be sufficient in order to bring a suit in the state court. It is not. Under the law, you need to be already reinstated in order to commence a proceeding, and what petitioner proposes here would in fact contravene the purpose of the statutory scheme by allowing a corporation to prematurely bring suit by merely showing some efforts without ever actually paying its taxes and getting reinstated. For all of those reasons, including those stated in our brief, we urge the court to affirm the decision below.
Thank you, counsel.
To deal with 4 points very quickly, if I may. First and foremost, there is no evidence in the record to support what the Attorney General has just said, that the Cloister Cafe never sought to do anything in terms of payment back. That's just made up. The Attorney General didn't subpoena or didn't get hold of any records from the state, from the Division of Corporations. The only evidence in the record is the 33-year payment of tax history by the Cloister Cafe, that they had been paying franchise taxes quarterly, they had been paying other than there was an issue over a tax audit, which is not the same as not paying taxes at all, first. Secondly, the question of the court asked regarding a waiver of a capacity defense, that we have at our brief, page 16, I believe it's pronounced Doughty versus Rosengarten, 180 MISC 2D 102. That defense can be waived. In relation to the fact that there are two different cases that seemingly the Attorney General says, well, we're going to recognize your capacity in one, but we're not going to recognize your capacity in another. Sorry, that doesn't wash. The case for Lowinger versus Lowinger that we cite to in our brief precludes a party who successfully assumed a certain position in a prior legal position and secured a judgment therein from assuming a contrary position in another. They went before one court and said, yes, we'll recognize it. Let's take it down to that other court. And just so you're aware what transpired with Justice Engron granted Cloister Cafe's vacateur of the summary suspension order, and then to stop an Article 78 proceeding, then the Attorney General withdrew the summary suspension order completely. There was never an Article 78 proceeding, and there is still ongoing proceedings before His Honor Judge Kaplan in relation to that. I would ask the court to look at Larissa. It says, it's apparent from the statutory scheme that the legislature did not intend a delinquent corporation which had not sought reinstatement to enjoy the privilege of corporate existence, which include the right to bring suit. It did not say it needed to be finalized before it was able to bring that suit. It's the seeking of reinstatement that Larissa speaks of, B&O speaks of, and 151st Street relies upon. The case law is clear in relation to this. I therefore respectfully request this appeal be granted and that Cloister Cafe be allowed its Article 78 hearings.
Thank you, counsel. Thank you both. Moose versus Triborough Bridge.